Hello aspirants, welcome to Introspection IS. In our ongoing series of prelims PYQs discussion on polity, we are excited to begin a new topic today, that is executive. Under this, we will discuss executive related to union and states. Like we will discuss under this, we will discuss the president, prime minister, governor, attorney general questions, advocate generals, and council of ministers. So kindly continue with us as we are carefully analyze these key topic in Indian polity to support your preparations for the upcoming examinations. So let's start the discussion. So the very first question of our topic was asked in 2023. So the questions says that consider the following statement. So it has given three statements and we need to find a correct one. Now this is one of the pattern which the UPSC has introduced, where it says that only one, only two, or all three, or none of the statement is true. For to answer this type of questions or this type of pattern, we need to be very confirm or be accurate for each of the statements. So let's see. The very first question is from the president, the executive of union. So it says that the first statement says if the election of president of India is declared void by the Supreme Court of India, all acts done by him or her in the performance of all duties of his or her office of president before the date of decisions become invalid, right? So here we need to understand the two key terms, that all the act he has done before his elections called off, or decisions by the Supreme Court will is valid or not, invalid, is invalid or valid, right? So through this to understand or to answer these questions, we should have aware about the Article 71 of the Constitutions, which says that any complaint or doubt about the election of president and vice president of India, then that doubt would be solved only by the Supreme Court. So no other authority in India has been allowed or empowered by the Supreme Court to hear the petitions related to the election disputes of president and vice president of India. So we can say that this power of Supreme Court is also can be called as an original, exclusive, and final jurisdiction. So this is an original, exclusive, and final jurisdiction of Supreme Court. Original, why? That it is directly reached to Supreme Court. Exclusive, why? Because no other authority other than the Supreme Court can hear matter election petitions related to the disputes related to president and vice president of India. And final, because the decision given by this Supreme Court in respect of disputes of elections of president and vice president is binding, on the government and cannot be challenged. So because of this jurisdiction of Supreme Court with relation to election disputes, with respect to president and vice president is original, exclusive, and final. Now let's see that the first statement says that if the election of president of India is declared void, means declared, it will be cancelled. So if suppose that Supreme Court says that election conducted and the person who is elected as a president is cannot hold office because his election is rigged or it is cancelled by Supreme Court of India according to Article 71. So that all the acts done by him or her in performance of her duties or his or her office of president before the date of decision become invalid. So can whatever he has done before his election was called off by the Supreme Court is invalid? No, it cannot be invalid. So the first statement is incorrect, right? Now after answering the first questions or first statement, we can come to the our options which has been given, and we need to find a correct. If suppose the first option is incorrect, if we are in a positions to find that the statement first statement as an incorrect, so we can mark that the this cannot be the answer, the C cannot be the answer, that is all three cannot be our answer. So now out of four we have eliminated one of the options, so we are left with the three options. The it may be only one is true, right, or only two is true, or none of the two, right? So the first is incorrect, right? Now to if we move further to this also, to this statement also, which says that if the election of a president is called void by the Supreme Court on election petitions, then his act done by him before the uh, judgment of the Supreme Court on his election cannot be invalid. And similarly, if suppose that the president is impeached also by the parliament. So in the case of impeachment of the president by parliament, his act also cannot be. So also his act before the date of impeachment, when the parliament impeached the president, an act is not valid. Sorry, is not invalid. So we can say that whatever he has act done before the impeachment process, all the act will be valid. So if he has issued any order, or if he has issued any directions or ordinance, or suppose that he has validated or he has given assent to any of the bill of the parliament, and that bill becomes an act, so after either the president is impeached or the president election is called void by the Supreme Court, that actions cannot be said that it is also invalid, right? So if any bill becomes an act and the president who has signed that bill as an act, so after declaring his election invalid or impeaching the president, it cannot be said that now the act is not valid because the president who has assented is not in a position, or he is no longer holding the post. Clear? So whatever an act person do in his capacity while holding the office of president or vice president shall not be invalid after his elections called declared void by the Supreme Court. Clear? So because of this, the first statement is untrue or incorrect. So we can say that now we are left with the three options: 1, 2, A, B, and D. Now let's move to the second statement. Says that election for the post of president of India can be postponed on the ground that some legislative assemblies have been dissolved and elections are yet to be take place. So to understand the second statement, we need to again move to the first statement, that is article 71, on the ground on which. So article 71 also says that on which ground the elections of a president or vice president can be and cannot be challenged in a Supreme Court or court of law. So the second statement says that suppose that when the elections is going on, so for that we can take an elections of this year elections of president. 2024 we have elected our president. So while the president election is due, or the election of the president is held, during that time the assembly of Jammu and Kashmir, though becomes an UT, is not in house. So there was no election held in the Jammu and Kashmir. So we can say that this so it is not a participant in the president elections, right? What is the statement 2 is saying that election for the post of president of India can be postponed on the ground that some legislative assemblies has been dissolved and the election are yet to be take place. It means it is talking about that there is a vacancy in the electoral office. And as we all know that the electoral office of the president combines elected members of parliament, elected members of state legislative assemblies, elected members of Delhi Assembly, Puducherry Assembly, and Jammu and Kashmir Assembly also, right? So these are the electoral college of the president. Now the second statement says that suppose that if there is a vacancy in either of this, like suppose that there is no during the time of elections, a Bihar Assembly is there is a president rule, or we can say suspended, or is dissolved, and no election held before the president elections. So Bihar MPs or MLAs cannot take part in an election of president because there is a vacancy in the Bihar assembly, or there is no assembly in Bihar, right? So on can be this ground to challenge or to postpone the election of president, right? Can it be challenged? No. Can it be challenged, or it can be a ground for postponement? No, this cannot not be also a ground for the postponement of the election of president. And also according to article 71, this cannot be also a ground to challenge an election of an president, that there is a vacancy, or there was a vacancy in the electoral college of president, and because of that vacancy the election is should be called void. So this cannot be our also correct statement. So second is also incorrect. Now after answering the second statement, again we will move to the options. So only two cannot be also answered because out of the three, the two statements are incorrect. Now we are left with the A and D. Now if it would have been not this questions and it had been a simple questions, so through till the time till the analyzing of the second statement we would have arrived at our answer. But this is another, or we can say that these are the another set of questions or mechanism what the UPSC has come to. uh, so we need to analyze all the given statements, but through this also we can say that here also we can apply some set of elimination method. Now moving to the next, that is a third statement of the questions. So question third says that when a bill is presented to the President of India, the Constitution prescribes time limits within which he or she has to declare his assent. So, and now it is related to the legislative power of the president. As we all know that there are certain power given to president by the Constitution of India. So one of the power of the given to president under the Constitution of India is legislative power. Now this third statement is about an assent of the president. It is related to assent, or in general language we talk about a veto power, but there is no term veto mentioned in the Constitution. So assent is mentioned. So here we can say that the question 3 option statement 3 talks about an assent, that is under article 111 of the constitutions. Now the constitution has empowered the president through article 111, that when any bill passed by parliament, then the bill is sent to the president for his assent. So under this it says that either president can assent the bill, or he can return the bill. If the bill is not money bill. And the third option he has that he can take no action, which can be said as he can use a pocket veto. But for either of the action he is been allowed to take into the under article 111, there is no time limitations. Is mentioned. So so it says that no time limit. It's in as soon as possible. It is the statement says as soon as possible he can return the bill. But the statement says that he has to declare his asset within a prescribed time limit, but this time limit is not mentioned in the Constitution of India. So accordingly, this also, the third statement is also is incorrect. So we can say that our option answer to this question is none of the given statement is incorrect. Is it clear? I hope this is clear. Now, if you see the explanation to this, Article 71 and 111, on according to which the question was asked. So, Article 71 of the Constitution deals with the matters related to election of the President and Vice President of India. So, it says that the responsibilities to resolve disputes related to election of President or Vice President lies with the Supreme Court of India. Right? Constitution has empowered Supreme Court to resolve the disputes with election of President and Vice President. The Supreme Court's decision in this matter is a final and binding, right? If the election of a person as vice president, president or vice president is declared void by Supreme Court, all act done by the individual in the performance of their duties before the court's decision remain valid to ensure continuity and stability in the governance. So on the according to Article 71, the first is incorrect, right? Is incorrect. Now, if we see the next statement, next line, the election of a person as a president or vice president cannot be challenged if there are vacancies among the member of the electoral college. So this is also according to Article 71, and on the basis of this also we can say that the statement 2 is also incorrect, because it cannot be postponed on the only on the ground that there are certain vacancies in the electoral college of president or vice president. Clear? So according to this, the first two statement lies on Article 71. Now if you see the for the third statement, so according to Article 111 of the Constitution of Indian Constitution, when a bill is presented to the president has the following options. What are the options? So he may give his assent to the bill, or he may withhold his assent to the bill, that he can use a pocket veto. But the term pocket veto is not mentioned. The term is not mentioned in the constitutions. In constitutions. Clear? Or he may return the bill if it is not a money bill for reconsiderations of the parliament. However, if the bill is passed again by the parliament with or without amendments and again presented to the president must give his assent to the bill. So it means that the third option talks about a suspensive veto. This talks about a suspensive veto, that he has been given one chance to reconsider or send the bill back to the parliament. But once the parliament with a simple majority send the bill back to president, so he is bound to give his assent. But in this, any of this options which is power under the three clause of Article 111, none of it says any time limit, that within a such time limit. So this, on the basis of this, the time limit, it is not been presented to Indian president, though there is a time limit for the USA president, that within a 10 days he has to take either of the actions. But Indian president has not been limited through the time limitations. So Article 111 does not specify a time period within which the president must declare his or their intentions of declaring whether he is taking whether he is assenting the bill or withholding a bill or returning the bill. Is it clear? So the answer to the very first question is D, that is none of the above statement is true. Now let's move to the next questions. Now the second question, this was asked in 2023. Now this is one of the questions where it is advised to the student that if you are not comfortable or if you are not in a positions to apply logic, so you should leave this questions. You should leave this question, because this is a question, this type of questions will be there in every examinations, every time of the examinations, where it does not only requires you can say that concept clearance or or we can say that a fact, but also requires to use some point of logic or reasoning behind to resolve this question, this type of question. So it is advisable to the students that whenever you see this type of questions, you should leave this questions, right? And at the end, when you have time, you can, if you are in a position to apply some logic, then you can try to solve this questions. But here we will discuss how to apply a logic. Here in this session we will see to what logic we should apply to solve this questions. So let's move to the questions. Now this question was asked in 2023. Says that consider the following statement in respect of election to the President of India. So it is related to the election of President. The very first question says the members nominated to either House of Parliament or a state or the legislative assemblies of states are also eligible to included in the electoral college of president. So no, this is not true. This is an incorrect statement. So according to constitution, the electoral college of president, as we have seen in the very first questions, it consists only elected members of parliament, that is elected member of Lok Sabha and elected member of Rajya Sabha. Then only elected members of state legislative assembly. No members of council were allowed to take part in election of president, right? So only the state legislative assembly, only those who are elected, not a nominated member also, right? And then only elected members of Delhi, legislative members, assembly members of Delhi, Puducherry are allowed to take part in election of president. So the very first statement says that nominated members to either house are also eligible to take part or be a part of electoral college. No. So the first statement is true. Now if we move to the statement that options, that how many of the above statement are correct. So all cannot be true, right? Now first is true, so we can say that all cannot be true. So only if only one statement can be true, only two true, or only three true, but all four cannot be true. So now if we move to the second statement, so second statement says, now from the second statement we need to apply certain section of logic behind this in the examination. So what logic we should apply? So here we will discuss this. So second statement says that higher the number of elected assembly seats, it means MLA, total number of MLAs into the assembly, total number of MLAs, that is assembly seats in house. So it says that higher the number of assembly seats, higher the value of vote of each MLA of that state, right? Now to understand this, let's apply some logic. So here we will see that right. So it says that if legislative assembly seats, a state having a legislative assembly seat is higher than the this is, suppose that this is the first state 1 which is having a higher number of legislative seats, so it will be having an then the second. So value of vote of each MLA of one state will be higher than the second state. So it is true or not? So to understand this, we will first of all see how a value of vote of each MLA is calculated. That is formula given in the constitution. So it says that to calculate a value of each MLA's vote, we need to first take a total population of a state based on 1971 census divided by total number of seats in assembly multiplied 1 by 1000. So this is a formula to calculate value of each vote, and by calculating this we can arrive to the value of each vote about which the question talks about. Now, so to understand this, let's take an example of a state with the value of vote and total populations. So if we take an example, so let's take example of MP, Madhya Pradesh and Kerala. So we should compare between the Madhya Pradesh and Kerala number of seats and their value of votes. Now, why we are taking an MP as an example and Kerala as an example? Because related to the third statement where it says the value of vote of each MLA of Madhya Pradesh is greater than of a value of vote of a Kerala, right? And the second and third statement is similarly, we can say that is a similar statement. Why? Because the Madhya Pradesh has highest number of MLA seats, right? So Madhya Pradesh having a higher number of MLA seats, that is of 230, whereas a Kerala has a lower number of seats than in comparison to Madhya Pradesh, that is 140. So second statement says that higher the number of elective assembly seats, that is 230, will also have a higher value of each MLA's vote. And third statement says the value of vote of each MLA of Madhya Pradesh is greater than that of Kerala. So to understand this, we will take an example of MP and Kerala. So if we see that MP's total vote, if we make a comparison here between the MP and Kerala, so we will MP, we will take this side to calculate, and this is a Kerala to be understood. So MP's total population in 1971 was 3 crore 17,000, and total number of seats is 230. So total population of states, that is 3 crore 17,000. Total number of seats in an assembly 230 divided by multiplied by 1 by 1000. Whereas in Kerala, the total populations in 1971 was 2 crore 13 lakh 47,375, and divide total by the 140 number of elected seats and multiplied by 1 by 1000. So if you calculate this, so MPs in MP, each MLA value of vote in MP will come around 131. So each MLA will having a value of vote of 131, whereas in Kerala it will come around 152, right? So through this example we can say that the third is also incorrect, right? Because the Kerala having a higher greater than the MLA MP, not the MP having a greater, right? Now if we come to the second, so it says the higher number of elective seats, whereas the MP has a higher number of elective seats, so its value of vote will also be greater. No, this is not true. Why? Because when a denominator, this is known as a denominator, and this is a numerator. So in a fractions there are two terms, one is numerator and one is denominator. So whenever denominator is greater, so value will all, denominator is greater or larger, or the denominator increase, so value will decrease. It will not increase the in proportionate. So we can say that its denominator, that is dividing the number of seats or number of MLAs, is 230. So its denominator is greater than the denominator of Kerala. So value of this number of seats in Kerala is less than number of seats in MP. So it will having a highest number of or greater number of value of votes in comparison to Madhya Pradesh. So on the logic of this also we can say that the second is also incorrect, right? So first, second and third is incorrect. So this cannot, only two cannot be answer, right? So two cannot be also answer. So two cannot be also answer. Only three cannot be answer. So we are left with the only one, that is A. Only A. So only one is true. It means the fourth statement is true. So to analyze the four, let's see the options. Statement 4. What does the statement 4 says about? So statement 4 says the value of vote of each MLA of Puducherry is higher than that of Arunachal Pradesh because the ratio of the total population of total number of elective seats in Puducherry is greater as that of compared to Arunachal Pradesh. So here also the same logic, that the denominations, the number of seats in Puducherry, number of seats in Puducherry has to be greater than the Arunachal Pradesh. So number of seats in Puducherry is 33, whereas in Arunachal it is 60. So Arunachal will have a lower value of vote with comparison to Puducherry. So this is also true, and it will have a Puducherry will have a higher value of vote of each MLA, right? So value of vote of each MLA of Puducherry is higher than that of Arunachal Pradesh. So this is true. So our answer to this question is only one. That is fourth statement is true. Now if you see the value of vote of each MLA is calculating using the formula, that is value of each MLA's vote is equal to total population of state 1971 census divided by total number of elective seats in assembly multiplied by 1 by 1000. This is 1 by 1000. 1 by 1000. If a state has a higher number of elected assembly seats, the value of each MLA's vote will generally be lowered because denominator is increased. So what we have seen in this case, that if the denominator is greater than the comparative to the denominator of second state, so if D1 is greater than D2, so the D1 will having lower value and D2 will having higher value. Is it clear? Yes or no? Okay. So this is the second statement. Now move to the next questions. The question number 3. Now this was asked in 2022. Now it says that I consider the following statement. The Constitution of India classifies the ministers into 4 ranks: Cabinet Minister, Minister of State with independent charge, Minister of State, and Deputy Ministers. Do the Constitution has classification of ministers, that is classifications of Council of Ministers? So no, it is has having no classifications. Only the Constitution mentions about the Council of Ministers, and with the one or two articles having a mention of cabinet, and rest of the places it talks about a council of ministers. So there is no classifications related to the council of ministers. This classification is basically derived of we can say that it is an administrative purpose and political purpose. This is mostly related to political and administrative purpose. So if we see the classifications of a council of ministers, so we can consider that this circle as a council of ministers. Now this circle council of minister consists of a cabinet minister, cabinet, the highest decision making body, decision making body. Then there will be a deputy minister, then minister of state, and then minister of state with independent charge. So all these four classifications are together known as a council of ministers, right? But this there is no such classifications, and cabinet being the highest and deputy minister being the lowest in this classifications, clear, of a council of ministers. So first is true. So A cannot be the answer and C cannot be the answer if we go through the analyzing, right, or elimination method. Now the next is the total number of ministers in the union government, including prime minister, shall not exceed 15% of the total number of members in the Lok Sabha. Yes, it is true, and this is through the 91st Constitutional Amendment Act has been proposed in the constitution, that the limitation that should be put limitations on the number of ministers, but it does not talk about any actual number. It is not, the constitution has not given any actual number, but it has talks in the terms of percentage, that not more than 15%, including prime minister, the council of ministers should have, right? So the 2 is true. So answer to this question is B, that is only 2. Now if you see here, it is a discussion, these two questions require a discussion of two article 74 clause 1, which says that there shall be a council of ministers with a prime minister at a head to aid and advise the president, who shall in exercise of his function acts in accordance with the such advice. Clear? So this 74 and many other articles has talks only about the council of ministers, but this has not been classified who comes under the council of ministers. Now it says that there will be a council of ministers headed by the prime minister to advise president, who shall in exercise of his functions acts in accordance with such advice, provided that the president may require the council of ministers to reconsider such advice, either generally or otherwise, and the president shall act in accordance with the advice tendered after such reconsiderations. So when the council of minister advise the president, so president has given one chance that he can return the considerations or send back the considerations to the council to reconsider once again. And if the council return after considering or without considering the uh, advice, then the president is bound to act on the advice given after such considerations. This classification is an administrative conventions, not a constitutional provisions. That classifications of cabinet, minister of state, minister of state with independent charge, and deputy minister. So this is more like an administrative and political conventions. The specific rank and designations are determined by the executive discretions and political considerations. So this has been be more related to the coalition government, when any political party try to form government with taking support from different political party. So the party which was supporting the government required some ministry. So to satisfy their needs, the classification has been done by the executive discretionaries. Is it clear? Now to understand the second statement, that is number of ministers in the cabinet. So this talked under article 75 clause 1a, which was added by the 91st Constitutional Amendment Act 2003, which states that the total number of ministers, including prime minister, in the council of ministers shall not exceed 15% of the total number of members of that house of people. So house of people means Lok Sabha. So it should not be compared to the house of parliament, right? But article talks about that the total member of House of Parliament. Why? Because House of Parliament is an elected, or we can say that representative of people. So they are directly elected representative, whereas the House of member of Rajya Sabha were indirectly elected. So this, the Lok Sabha being a power of an empowered, it is of a theory that people through their representative in Lok Sabha, they try to induce into the government and decision making of the government. It's clear? So this is the third question which was asked in 2022. Now let's move to the next question. Next question was also asked in 2022. Now this is related to the Attorney General of India, right? So consider the following statement. Attorney General of India and Solicitor General of India are the only officers of the government who are allowed to participate in the meeting of Parliament of India. So we need to find the correct. So they are the only one. So in this statement, it will be incorrect on the two line. First, they are not the only, and not the Solicitor General of India is allowed to participate in proceeding of Parliament, but only the Attorney General among the two is allowed. And along with this, the CAG officer is also allowed to participate. So on the line of two, we can say that this is incorrect. First, that if we compare these two, Attorney General and Solicitor General, so according to Constitution, Solicitor General is not a constitutional or body. It is not a constitutional office, or it is not an executive. Only the Attorney General of India is a constitutional executive or office, we can say that. And because of this, the Attorney General of India is allowed to participate in a parliamentary meeting or any parliamentary committee meeting. Parliamentary committee meeting. But not only, and this, on the second line, that they are not the only, the CAG is also allowed to participate in any of the meeting. So on this line, we can say that the first is incorrect, right? So which of the given statement are correct? So this cannot be our answer, and this cannot be our answer. So now either A or D can be answered. Now if you see the second statement, that according to Constitution of India, the Attorney General of India submits his resignation when the government which appoints him resigns. So it is true. This is the provisions that Constitution talks about. So this is also incorrect. So our answer to this question is D. Now, clear? But if we analyze the second option, so this is a convention. This is a convention. This is not political. This is not constitutional. This is not what the Constitution talks about. But in convention, it is true. So if the statement would have started with that, according to convention, the Attorney General of India submits his resignation when government which appoints and resigns. So yes, it is true. But the Constitution has no provisions with respect to any such incidents or circumstances. Now, if we talk about a convention, so there are two offices. One is Attorney General of India and another is Governor of State. So basically, these are the two statements, two of the offices which comes under the direct control or discretionary of a executive, right? So they are the call as an office of executive of union, and they are being employed, or they are being the governor is directly under the control of union, and the state has no, you can say that, any control over the appointment and removal of governor. So the convention says that when an appointing government resign from his office and the next government come into the office, so it is more high chance that the opposition who come into the government may remove these offices, because these have been appointed by the previous government. So to avoid the humiliations, they, as soon as the government resign, they also resign from their office. But this is a convention. This is not a constitutional. Clear? Now let's see the constitutional provisions with respect to the given two statement. So the first is Article 88 talks about rights of ministers and Attorney General as respects House. So it says that every minister and the Attorney General of India shall have the right to speak in and otherwise to take part in the proceeding of either house. any joint sitting of the House, and any committee of Parliament of which he may be named a member, but shall not by virtue of this article be entitled to vote. So, Attorney General of India is allowed to take part and speak in House of Parliament. House of Parliament, but he is not allowed to, but not to vote. Why he is not allowed to vote? Because the vote in the Parliament is only by the member of the House, only by member of the House, member of House. So suppose that one member, that if suppose we say that a government having a finance minister from Rajya Sabha, so he can speak in Lok Sabha, he can answer all the queries of the Lok Sabha, but he cannot vote in Lok Sabha. Vote in Lok Sabha. He can only have a power to vote in Rajya Sabha because he is a member of a Rajya Sabha. So to vote in Parliament, the person has to be a member of, and the person who is a member of the respective house can only vote in the house, in the only that house. So Attorney General is allowed by the constitutions to take part in the proceedings. He can speak for any matters. He can take part, debate. He can take part in the debate in the house, but he cannot vote because he is not a member of the house. And if you see the Solicitor General, so Solicitor General is a statutory office, is not a constitutional one, and hence does not participate in parliamentary proceeding. The Solicitor General of India does not have a constitutional provisions that allows participations in parliament. Is it clear? So this is related to the first statement. Now if you see the second statement, second with this respect to second statement, so article 76 talks about the Attorney General for India. Now it said the president shall appoint a person who is qualified to be appointed a judge of a Supreme Court to be the Attorney General of India. It shall be the duty of Attorney General to give advice to the government of India upon such legal matter and to perform such other duties of a legal character as may from time to time be referred to or assigned to him by the president, and to discharge the functions conferred on him by or under his constitutions. In the third says, in the performance of his duties, Attorney General shall have a right to audience in all courts in territory of India. The Attorney General shall hold office during the pleasure of President and shall receive such remuneration as the President may determine. So the second statement is incorrect because Constitution has nothing said that he has to resign when the government resign, but it says that Attorney General shall hold office during the pleasure of President. So it comes under the discretion of President, that he can be, or not a discretion of President, but the discretion of executive, that he can be removed by the President. And when we talk about the pleasure of President, it means that his removal process and manner not mentioned in the constitution, not mentioned in constitutions. And so how he can be removed and on what ground he can be removed, there is nothing said in the constitutions. And because of the absence of these terms, it says that Attorney General is on the pleasure of President. Is it clear? Right? But conventionally two is true, but constitutionally it is false. Okay. Now moving to the next, that is the next question, fifth question that was asked in 2020. So consider the following statement. So first statement says, according to the Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months even if he or she is not a member of that state. So second, if we see that a person can be made a minister in a state if he is not for a 6 month, if he is not a member, is true, right? But if we see the very first statement, that according to Constitution of India, a person who is eligible to vote, so eligibility of vote is 18 years in terms of age, and to become a minister a minimum requirement age is 25 years. So a person who is an 18-year is eligible to vote, but he is not eligible to hold the office of ministry. But any person who is 25 years of age or more than 25 years of age, so he can be made a minister for 6 months without being a member of house. But within a period of 6 months, he has to become a member of the house, either elected or nominated. Clear? But this the second half is true, but the first half is false on the or incorrect. So in this basis, we can say that the first statement is incorrect. So if we eliminate our options, so first cannot be answer and C cannot be answer. Now next, according to Representation of People Acts 1951, a person convicted of a criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting an election even after his release from prisons. So it is this the whole statement is incorrect because of this line, that is permanently disqualified. The person is not permanently disqualified, but he is disqualified for a period of 6 years from his release, right? So any person who has been convicted on criminal offense and be punished for 2 years or more than 2 years or more than 2 years, so the person will be ineligible for the 6 year after his release, that he cannot contest elections. So this is also incorrect. So our answer to this is D, that is neither 1 and nor 2. Now if we see the explanations related to first statement, so according to Article 173, which talks about qualification for membership of the state legislature, so it says that a person shall not be qualified to be chosen to fill a seat in the legislative assembly unless he is a citizen of India and makes and subscribe before some persons authorized in that behalf of election commission an oath or affirmation according to the form set out for the purpose of third schedule. This is mentioned in constitutions. Then second is, unless he is in case of seat in legislative assembly not less than 25 years of age. So he can only become a member if he is more than 25 years of age in assembly, and in case of seat in legislative council not less than 30 years of age. So to become a member of council, he has to be minimum of 30 years of age, right? So on the basis of this provisions of constitution, the first is incorrect. Now next statement says that unless he possesses such other qualifications as may be prescribed in that behalf by or under any law made by the parliament. So the constitutions only talked about the two qualifications to be a member of legislative assembly, and the third is given to the parliament, that through law the parliament can also discuss or can also prescribe any qualifications required to be a member of house, right? So first is incorrect on the basis of B. Now if you see the second statement explanation of this, so as per the section 8 of Representation of People's Act 1951, a person convicted of an offence and sentenced to imprisonment for not less than 2 years shall be disqualified from date of such conviction and shall continue to be disqualified for the further period of 6 years since his release. Not an permanently, he is not permanently disqualified, but he will be disqualified for the 6 years. So right, so this also explains why the second statement is incorrect. So answer to this question is D.